The envelope had been sitting in Vivienne Aucaffer's desk drawer for 11 months. She had told me about it 2 weeks before she died, not in a dramatic way, not with ceremony. She mentioned it the way she mentioned most significant things, between 2 other topics, in the middle of Tuesday lunch, as though the importance of a thing did not require a special frame to announce it. She said, "There is an envelope in my top right drawer at the office. Sealed, my name on the front. You are not to open it until the estate meeting. You will know when." I said, "What's in it?" She said, "What needs to be in it?" That was the whole of the conversation. She poured more tea. We talked about something else. 11 months later, I was in the conference room of Aucaffer and Associates in downtown Houston, sitting at the head of a table. I had sat it 3 times a week for 9 years. And across from me were the people who had driven 4 hours from New Orleans because they had heard about the estate and believed that hearing about it entitled them to a portion of it. My grandmother, Celestine, in the black dress she wore to every significant occasion. My uncle Theodora, who had not spoken to Vivienne in 6 years, but whose attorney had spoken to her estate attorney 11 days after her death. My Aunt Marguerite, who had brought a notarized letter asserting her status as the next of kin of the deceased. And my cousin Ramai, who was 29 and had never held a job for longer than 8 months, and who was wearing a watch that was significantly more expensive than anything I had seen him wear in the 3 or 4 times I had encountered him in the previous decade. Vivienne Aucaffer was my great-aunt. She was 71 years old when she died, and she had been an immigration attorney for 43 years, and she was the most deliberate person I have ever known. She did not do anything by accident. She did not leave things unaddressed. She did not open a drawer in the morning without knowing exactly what was in it. The envelope had been in that drawer for 11 months. I had not opened it. Celestine had been talking for 4 minutes when the estate attorney, a man named Roland Thibodeaux, who had been Vivienne's colleague for 22 years, opened the conference room door and set the envelope on the table in front of me. He said, "She said you would know when." I looked at the envelope. I looked at Celestine. I looked at Theodora, who had flown in from New Orleans with his own attorney. I said, "I know when." I opened it, and everything that followed was exactly what Vivienne had prepared for. Let me take you to where this started, because the envelope was the ending, and the ending only means something if you understand the beginning. My name is Solange Mercier Aucaffer. I am 32 years old. I am a licensed immigration attorney and the managing partner of Aucaffer and Associates in Houston, Texas, a firm I have managed for the past 3 years following the death of its founder. I have a master's degree from UT Austin and passed the Texas bar on my first attempt at 25. I am telling you this not to catalog my achievements, but because the people who tried to take what Vivienne left me used my youth and my gender and my background as arguments for why they should have it instead. And I want to be precise about what they were actually arguing against. I grew up in Beaumont, Texas, the younger of 2 daughters of Colette Mercier, who worked dispatch at a trucking company and raised us in the specific economy of a single mother doing the arithmetic of insufficient income against essential expenses, with the kind of skill that never gets formally recognized as skill. My older sister, Anais, was everything that made my mother's social presentation easier, pretty in the way that earned compliments from her colleagues, socially fluent, the kind of child who moved through adult spaces without creating friction. I was quieter, more internally oriented, the one who read during family gatherings rather than circulating, who asked questions that were accurate but sometimes unwelcome in their timing. My mother loved us both. I want to say that clearly because what I am about to describe is not a story about a mother who did not love her child. It is a story about a family whose organizing logic was not love but performance, and what happens when one child performs well for that logic and another does not. Anais was 3 years older than me and had a gift for understanding what rooms needed from her and providing it. Teachers liked her immediately. Relatives described her as a joy. My mother's friends said she was going to do something remarkable, though they could not always specify what. She was the center of our family's social identity in the way that some children become the center, not through any fault of their own, but through the specific alignment of their natural tendencies with what the surrounding environment rewards. I was not that alignment. I was curious about things the family did not find interesting and uninterested in things the family found important. I was good at school in a way that produced grades rather than warmth, which meant it was noted and moved past rather than celebrated. When I won the regional academic decathlon in 8th grade, my mother came to the ceremony and said nice things, and then spent the drive home asking Annalise about the fall drama production she was planning to audition for. I am not recounting this to build a case against my mother. She was doing what she knew. The pattern was the pattern. I am recounting it because the pattern was the thing that eventually put me at Vivienne's door, and Vivienne's door was the thing that changed everything. My great-aunt Vivienne Aucaffer had married into the family when she was 26 and had been present at its edges for my entire childhood. Present at holidays, present at significant events. Present in the specific way of someone who attends consistently, without being absorbed into the family's organizing logic, because they arrived as an outsider and have always retained a slight outsider's distance. She was my grandfather's brother's wife, which made her technically a great-aunt by marriage rather than blood, a distinction my grandmother Celestine made regularly and with emphasis. Celestine considered Vivienne's presence in the family tolerated rather than earned. This was partly about the marriage itself. Vivienne had met great-uncle Joseph at a legal conference and married him within a year, which Celestine received as an act of social ambition, and partly about Vivienne's professional success, which had accumulated steadily over 4 decades into something that could not be ignored, and that Celestine responded to by ignoring it pointedly and consistently. Vivienne had founded Aucaffer and Associates at 34, after 12 years at a larger firm. She had built it into one of Houston's most respected immigration law practices over the following 3 decades, with 11 attorneys and a client base that included individuals, corporations, and nonprofit organizations. Great-uncle Joseph had died in 2009. Vivienne had kept building after he was gone, the way people build when building is the thing that makes sense of everything else. She had no children. I had not thought much about this fact for most of my childhood. Children do not generally think about the childlessness of adults they encounter at holidays. It is simply a feature of the landscape. I started thinking about it the summer I was 15. That summer, Annalise had been accepted into a pre-college theater intensive at a university in New Orleans. 6 weeks, residential, significantly beyond what my mother's budget could absorb. The conversation at the kitchen table was the kind I had learned to recognize, the specific quality of my mother's problem-solving voice, the way she worked through numbers out loud, the conclusion forming before it was stated. She said, "There's a summer research program at Rice University that you've been looking at." I said, "Yes." She said, "It costs money we don't have. Annie's program costs money we don't have. We can't do both." I said, "The Rice program has a scholarship application." She said, "I know. But even with a scholarship, there are fees and transportation, and we can't manage 2 programs this summer. One of you will have to sit this one out." I already knew, before she said it, which one of us it would be. She said, "Annie's program has been on the calendar for a year. The casting director from her school recommended her specifically. It would be wrong to pull that back now." I said, "The deadline for the Rice scholarship is Friday." She said, "I know, baby, I'm sorry." She meant it. She was genuinely sorry. That was the part that was hardest to hold. That the decision was not cruel, it was just the natural consequence of a logic that had always distributed resources according to where they were most visibly needed. And I had never been the place where they were most visibly needed because I had learned to need quietly. I went to my room. I stayed there for most of that evening. At some point, I heard a knock at the front door. Then my mother's voice, surprised and warm in the way she was warm for family. Then a second voice, lower, deliberate, "Vivienne." She had not been expected. She had driven 2 hours from Houston on a Tuesday evening in July without calling ahead, which was entirely unlike her, because Vivienne called ahead for everything. I heard them in the kitchen for 45 minutes. I could not make out words, just the cadence of the conversation. My mother's voice defensive at first, and then something else, something that moved through several registers before arriving at something quieter. Then Vivienne knocked on my door. She came in and sat on the edge of my desk chair, not the bed, the desk chair, the chair that was for work, and looked at me for a moment. She said, "Your mother tells me you were looking at a summer research program." I said, "It doesn't matter." She said, "It does matter. Tell me about it." I told her. The program, the research focus, environmental science, specifically the chemical analysis of urban water systems, the faculty involved, the scholarship I had identified that would have covered most of the cost. Vivienne listened to all of it with the specific attention of someone who has spent a career parsing what is actually being said beneath what is being presented. She said, "Have you submitted the scholarship application?" I said, "Not yet. The deadline is Friday." She said, "Submit it Friday." "I'll speak with your mother about the remaining costs," I said. "She already decided." Vivienne said, "She decided with the information she had. Now she'll have different information. I submitted the application Friday. I was accepted." Vivienne paid the fees that the scholarship did not cover. My mother, after a conversation with Vivienne that I was not present for and have never been told the full content of, said nothing beyond "You'll need to pack by next Sunday." I went to the program. It changed me in the way that encountering the right environment at the right developmental moment changes a person. Not dramatically, not in any single revelatory instant, but cumulatively. Through 6 weeks of working, alongside people who were interested in the same things I was interested in, for the same reasons I was interested in them, and discovering that the version of myself that was easiest to be was also the most capable version. I came home at the end of August. Annie's came home a week later from New Orleans, where she had apparently been a significant success. There was a family dinner to celebrate her return. My mother made a cake. No one asked about my summer. I went back to school in September. I kept in contact with Vivienne because she had given me her direct line on the last day of the program and told me to use it if I needed anything. I used it carefully at first, and then more frequently as I understood that she actually meant it. She had meant it. Over the following 10 years, from my junior year of high school through my bar admission at 25, Vivienne was the most consistent presence in my professional development. She recommended books and then asked me specific questions about them the following month. She introduced me to colleagues in fields adjacent to law when she thought the introduction would be useful. She wrote me a recommendation letter for UT Austin that her colleague, who sat on the admissions committee, later described to me as the most detailed and specific letter of recommendation he had received in 11 years of reviewing applications. She also, when I was 22 and in my first year of law school, and struggling with the specific exhaustion of an environment that rewarded a kind of competitive performance I was not built for, called me on a Thursday evening and said, "I want to offer you a summer position at the firm next year. Research and drafting. You'll be paid. Think about whether you want it." I thought about it for approximately 6 seconds. I said, "Yes." The summer at Acaffer and Associates was the summer I understood what it felt like to work somewhere that was built on the same values I held rather than values I was performing in order to be accepted. Vivienne ran the firm with precision and with genuine care for the people inside it, the attorneys, the staff, the clients, the cases. She believed that immigration law was fundamentally about human dignity and that every document filed and every hearing prepared was an expression of that belief. She said this not in speeches, but in the specific standards she held for the work and the specific way she treated everyone who came through the door. I came back the following summer, and the summer after law school, when she offered me a full position at the firm. I had other offers, not dramatically better, but legitimate ones, from firms with larger platforms and more immediate name recognition. I chose Ackhafer and Associates because I understood, by the time I was 25, that I was not choosing a job but a context, and the context Vivienne had built was the right one. She made me senior associate at 27, managing associate at 29. When she began to slow in her final 2 years, not dramatically, Vivienne never did anything dramatically, but incrementally, in ways visible only to someone who knew her work and her rhythms, she began giving me more of the firm's operational responsibilities, not announcing this. Just adjusting what came to my desk and what came to hers. The diagnosis was congestive heart failure, identified in the fall of the year before she died. She told me in the same Tuesday lunch register she used for everything significant, between 2 other topics, without ceremony. She said, "I have a heart condition. It is manageable for now and will not be manageable eventually. I want you to be informed rather than surprised." I said, "What do you need from me?" She said, "Keep the firm running the way you've been running it, the same standards. The same culture, nothing changes." I said, "Okay." She said, "And there is an envelope in my top right drawer." The 8 months between the diagnosis and her death were the most demanding of my professional life, and also, in a way that I could not fully articulate at the time, the most clarifying. Vivienne and I worked alongside each other during those months with the specific efficiency of people who understand that the time available is finite, and that efficiency is therefore an act of respect rather than urgency. She finished the cases she needed to finish. She introduced me formally to every client relationship that would need to continue. She conducted a review of the firm's governance documents with Roland Thibodeaux and spent 3 separate afternoons updating them. She died on a Tuesday morning in February, peacefully, in her house in the Memorial neighborhood, with her housekeeper present and me on my way. I was 3 minutes away when Roland called. I sat in my car outside her house for a long time before I went in. The week after her death produced the specific administrative avalanche of significant loss. The notifications, the arrangements, the condolences, the decisions that have to be made regardless of what you are feeling because the world's systems require decisions. I managed all of it with the competence she had developed in me because that is what she had developed it for. What I was not managing was the family. The family had been informed. Roland had made the relevant calls. The obituary had run in the Houston Chronicle and apparently in the New Orleans Picayune because Vivienne had kept contacts there through her work. And those obituaries had mentioned the firm and, in the Chronicle's version, had described me as Vivienne's protégé and the firm's managing partner. My grandmother Celestine called me the morning the Chronicle obituary appeared. She said, "I read the piece. Protégé, that's quite a description." I said, "It's accurate." She said, "Vivienne left quite a practice from what I understand." I said, "Yes." She built something significant. A pause. "Then, as family, we'll of course be involved in the estate proceedings. Theodora has already been in touch with someone about representation." I said, "I'm not sure what proceedings you're anticipating, Celestine. You should speak with Roland Thibodeaux." She said, "We'll be speaking with Roland, yes, and with you. Family needs to be included in these things." I thanked her and ended the call. I called Roland immediately after. He said, "I know. Theodora Mercier-Fontenot's attorney called me 2 days ago, and Celestine's attorney called this morning." I said, "What are they claiming?" He said, "Familial interest in the estate. They're arguing that as the biological family of the deceased, specifically, that as the surviving family of great-uncle Joseph, through whom Vivienne was connected to the Mercier family, they have standing to contest any estate plan that doesn't include them." The argument was legally creative and professionally thin, but Roland explained that thin arguments, when pursued aggressively, could still create significant disruption. Vivienne's estate included the firm's assets, her personal investments, her properties. A contested estate could freeze operations while litigation proceeded. For a law firm, frozen operations meant clients in limbo and cases at risk. I said, "She anticipated this." Roland said, "She anticipated this exactly. That's what the envelope is for." I did not open the envelope. I held it for 11 months, while Roland managed the family's escalating legal maneuvers. Their formal demand to attend the estate proceedings, their filing of a preliminary challenge on grounds of undue influence. Their submission of an affidavit from Celestine asserting that I had isolated Vivienne from her family during her illness and manipulated the estate planning for my own benefit. The affidavit described me as an opportunist who had exploited an elderly woman's loneliness. I filed it with Roland. I continued running the firm. I handled 114 immigration cases in those 11 months, which is not a figure I offer for sympathy, but for context. The work was real and ongoing, and required the full attention I gave it. And I gave it that attention because Vivienne had trusted me with it, and because the clients depended on it, and because doing the work correctly was the answer to every implication in Celestine's affidavit. I was running the firm. I was serving the clients. I was doing exactly what Vivienne had built me to do. The estate meeting was scheduled for the second Tuesday in January, 11 months after her death. Roland's conference room occupied the corner of the 4th floor of a building on Westthamer, with windows that looked over a stretch of the city Vivienne had practiced in for 4 decades. He had arranged the room for 14 people. 8 seats at the main table for the attorneys, the estate representatives, and the relevant parties. Additional chairs along the wall. I arrived 20 minutes early, as I always arrived, and sat at the seat Roland had designated for me at the head of the table. I had the firm's operational reports for the 11 months since Vivienne's death in the folder in front of me. I had my own records. I had, in my inside jacket pocket, the copy Roland had given me of every document Vivienne had filed with his office in the 3 years before her death. I did not have the envelope. Roland had it. He would bring it when the time came. Celestine arrived at 2 minutes past the scheduled time, which was how she always arrived slightly late, to establish that she was not waiting for anyone. She wore the black dress, the pearls. The expression she wore when she believed she was the most significant person in a room, which was most rooms. Behind her, Theodora. He was 57, my mother's cousin, a man who had been adjacent to every Mercier family gathering for my entire life, without being materially present in any of them. He was wearing a suit that was slightly too large in the shoulders, and was accompanied by his attorney, a man named Garrett Fonvielle who carried an aluminum briefcase and had the specific energy of someone billing by the hour. Marguerite arrived separately, also with an attorney. Her attorney was younger, sharper-looking, the kind of associate who had been sent rather than chosen. Ramai was last. He looked around the conference room with the expression of someone who expected more. Whether he expected more space or more ceremony or simply more was unclear. Celestine's gaze found me immediately. She said, "Solange, you look well." I said, "Celestine, not Grandma, her name." Something shifted in her expression briefly and then resolved back into its normal configuration. She said, "I hope we can approach today cooperatively. This doesn't need to be adversarial, we're family." I said, "The proceedings will begin when Roland is ready." Roland entered 2 minutes later. He greeted everyone with the professional warmth of an attorney who is very good at his work and who has been managing a complex situation for 11 months and is now, finally, ready to conclude it. He said, "Thank you all for attending. We're here to conclude the estate proceedings for Vivienne Aucaffer, who passed on February 14th of last year. Before we begin the formal reading, I want to address the pending legal challenge filed on behalf of the Mercier family." Garrett Fonvielle straightened. Roland said, "The challenge alleges undue influence, claiming that Ms. Solange Mercier Aucaffer manipulated the deceased during her final years and directed the estate planning for her personal benefit. I want to address this directly and with documentation, because Ms. Aucaffer herself requested that the record be complete." Celestine looked satisfied. She had expected a fight. She was about to get something different. Roland produced a document from his folder and placed it on the table. He said, "This is a psychiatric evaluation conducted by Dr. Patricia Elias at Houston Methodist on November 3rd, 3 years before Ms. Aucaffer's death. The evaluation was conducted at Ms. Ackafer's own request and confirmed that she was of full sound mind and was under no undue influence of any kind in her estate planning. The evaluation was repeated annually for the following 2 years. All 3 evaluations reached the same conclusion. Garrett Fonvielle looked at his copy. His expression did not change, but his pen stopped moving. Roland said, "The estate documents were prepared by my office beginning 4 years before Ms. Ackafer's death, well before her diagnosis, and were updated regularly with proper witnessing and documentation at every stage. The claim of undue influence is not supported by any evidence in the record and is contradicted by 3 years of documented psychiatric evaluations." Celestine's attorney, a quiet woman named Bernadette Chu who had said nothing since entering the room, leaned toward Celestine and said something low. Roland continued, "I'd like to address one more preliminary matter before we begin the reading." Mr. Théodore Mercier-Fontenot's attorney argued in his challenge, filing that Mr. Mercier-Fontenot has standing as a blood relative of the deceased through the deceased's marriage to Joseph Ackafer. Théodore nodded, as though this confirmation were simply the first step toward an obvious conclusion. Roland said, "Ms. Ackafer anticipated this argument. It is addressed in the estate documents directly." He turned to the door and nodded to his assistant, who appeared with a sealed envelope and placed it in front of me. Vivienne's handwriting on the front. I opened it. Inside was a single folded document and a handwritten letter. The document was dated 11 months earlier, 2 weeks before she died, and was notarized by 2 witnesses. The letter was undated and in Vivienne's handwriting and was 3 pages long. I unfolded the document first. It was a formal statement of family history and relationship documentation, prepared by Vivienne in her own professional capacity, notarized and witnessed, setting out the precise nature of her relationships with the members of the Mercier family who had filed challenges against her estate. I read it aloud, as Roland had told me she had requested. The statement noted, first, that Vivienne Ackafer had been married to Joseph Ackafer from 1979 until his death in 2009. During that marriage, she had attended family gatherings, contributed financially to family events on multiple occasions, and maintained relationships with family members at varying degrees of closeness. She noted that in the 23 years of her marriage, Théodore Mercier-Fontenot had borrowed money from her on 3 separate occasions. In 1991, in 1998, and in 2003, totaling $42,000, and had repaid a total of $6,000 across those 3 loans. Théodore made a sound. She noted that in the 6 years prior to her death, Théodore had made no contact with her whatsoever. She noted that Celestine Mercier had, at a family gathering in 2016, referred to her in terms she chose not to reproduce here, but which had been witnessed by 4 people whose names she listed. She noted that Marguerite had filed a lawsuit against Vivienne's firm in 2014, alleging that she had improperly handled an immigration matter for a distant cousin. The lawsuit was dismissed at the summary judgment stage. Vivienne noted this without editorial comment. Then she addressed Ramai, who was 29 and had the most expensive watch in the room. She noted that Ramai had contacted her firm in 2021, 2 years before her diagnosis, requesting that the firm handle an immigration matter for him at no charge on the basis of family connection. She noted that she had declined this request on the grounds that the firm's charitable capacity was reserved for clients who could not afford representation, which Ramai demonstrably could. The room was very quiet. I set down the document. I looked at Celestine. Celestine's expression had undergone several changes during the reading and had arrived at something that was trying to be composed and was not quite getting there. I said, "She prepared this so the record would be complete. Those are her words." Celestine said, "This is one side of things." I said, "It's the side with documentation." I unfolded the letter. Roland said, "Ms. Ackafer requested that portions of this letter be read aloud." I read the portions she had marked. She wrote, "Solange came to me as a 15-year-old girl who had been taught to need less so that others could have more. She never complained about this. She did not ask me to intervene. I intervened because what was being done to her was a waste, and waste is the thing I have always found least forgivable. She was not a project. She was a person with a specific and remarkable mind who needed a context in which that mind could operate. I provided the context. She did the rest. Ramai looked at the ceiling. She wrote, "I have no biological children. This has never been a source of grief for me because grief requires the loss of something you expected, and I never expected children." What I did not expect was Solange, and what I found in her over 17 years of professional development and genuine friendship was the most complete expression of everything I had tried to build: the intelligence, the ethics, the care for the work and for the people the work serves. She is not my heir because she is the most convenient option. She is my heir because she is the right one. Marguerite's attorney wrote something on her legal pad. She wrote, "To the members of the Mercier family who have filed challenges against my estate, I offer the following. You are welcome to pursue whatever legal remedies you believe are available to you." I have spent 43 years in the law, and I prepared these documents with the same care I applied to every case I handled. You will not find a vulnerability in them because I did not leave any. What I am less able to address is the question of why you feel entitled to benefit from a relationship you did not maintain. I leave that question to your own consideration. I folded the letter. I looked across the table. Garrett Fonvielle and his aluminum briefcase had gone entirely still. Bernadette Chu, Celestine's attorney, leaned forward. She said quietly to no one in particular, "The psychiatric evaluations alone would defeat the undue influence claim, and the relationship documentation she has prepared is significant for standing arguments." Fonvielle said, equally quietly, "Combined with the loan documentation for Theodora's unpaid debts, the estate could potentially counterclaim for the outstanding $36,000. These two attorneys, hired by opposing parties, were arriving at the same conclusion through their own calculations. Vivienne had understood this would happen. She had prepared the documents that made it inevitable. Theodora said, "This is not fair." I said, "Theodora, with respect, you borrowed $42,000 and repaid $6,000. You didn't speak to her for 6 years, and now you're here because you heard the word estate." He said she was family. I said, "She tried to be. She was at every gathering for 30 years. She sent gifts. She attended funerals and weddings and celebrations. The relationship was available to anyone who wanted to maintain it. You chose not to." He started to speak. I said, "And when Roland informs you that Vivienne's estate counterclaim for the outstanding $36,000 in unpaid loans can be filed simultaneously with your challenge, I think you'll want to reconsider whether continued litigation is in your interest." Fonvielle looked at Theodora. Theodora looked at the table. Celestine had been quiet for 2 minutes, which was the longest I could remember her being quiet. She said, "Solange, I raised your mother. I am your grandmother. This is not how family behaves." I said, "I know you raised my mother. I know what family means to you. But Vivienne was part of this family for 30 years and was treated as an outsider for most of them. And she built something remarkable anyway, and she chose to leave it to the person who chose her. I think that's a decision she made clearly and correctly, and I'm not going to apologize for being that person." Celestine said, "You could still include the family. We are not asking for everything." "A portion," I said. "You are asking for everything you can get. That is different from asking for a portion." She stopped. I said, "I don't hold any of this against you personally. But I'm not going to give you money to resolve a challenge that has no legal merit because the discomfort of a contested proceeding makes it simpler to pay you off. That's not something I'm willing to do." Roland cleared his throat. He said, "Mr. Fonvielle, I should note that the counterclaim for the outstanding loan balance can be filed as early as this afternoon if the challenge proceeding continues. My recommendation, purely as a professional matter, is that your clients consider their position carefully before we proceed further today." Fonvielle said something to Theodora behind his hand. Then he straightened. He said, "We would like a brief recess to consult with our clients." Roland said, of course. 20 minutes. The four of them, Celestine, Theodora, Marguerite, and Ramai, filed out with their attorneys into the hallway. Through the glass wall of the conference room, I could see the shapes of two consultations happening simultaneously, both attorneys gesturing in the specific way of professionals, explaining something their clients did not want to hear. I sat at the head of the table and looked at the operational reports I had brought. 114 cases, 97 resolved favorably, 11 pending, 6 in appeals. The firm had maintained its client base through the transition and had added 9 new clients in the 11 months since Vivienne's death. The culture she had built was intact. The standard she had held was intact. Everything she had left was functioning exactly as she had designed it to function. Roland sat beside me. He said, "How are you doing?" I said, "I'm okay." He said, "She was right about you." I want you to know I thought so independently, not because she told me to think so. I said, "Thank you, Roland." He said, "She also told me to tell you if this day went the way she expected, that you handled it correctly." And that the look on Theodora's face was something she regretted not being there to see. I laughed, the real kind. After 19 minutes, the parties returned. Fonvielle spoke first. He said, "After consulting with our clients, we are withdrawing the challenge to the estate. We will be filing the withdrawal paperwork with the court by the end of business today." Bernadette Chu said, "The same on behalf of our client." Marguerite's attorney nodded. Roland said, "Noted. We'll proceed with the formal reading." The reading took 45 minutes. I will not reproduce the full terms because some of them are the firm's business and therefore not mine to share publicly. What I will tell you is the shape of it. Vivienne left the firm to me, the assets, the client relationships, the lease, the accounts, the professional standing it had accumulated over 40 years. She left it not as a gift, but as a transfer of something I had already been running, which is the most honest way to transfer something. She left her personal investment portfolio in 2 portions, 70% to me and 30% to an endowment she had established at UT Austin's law school for immigration law scholarships, specifically for first-generation students from underrepresented backgrounds. She left her house in memorial to me with a note in the estate documents that said simply, "You should have a house that matches the life you are building." She left nothing to Theodora, Marguerite, Ramai, or Celestine. She named each of them in the estate document with a brief notation beside each name explaining why. For Theodora, the outstanding loan balance. For Marguerite, the dismissed lawsuit. For Celestine, a single sentence that I read and chose not to read aloud, and that Roland confirmed I had no obligation to share with anyone. For Ramai, she had written, "I hope he finds work he cares about. That is not something money can provide." When Roland concluded the reading, the room had the specific quality of a space where something significant has been completed. The charity representatives, the UT Austin Endowment Director, and 2 representatives from Houston immigration advocacy organizations Vivienne had supported, gathered their notes. Roland's assistants began organizing the documentation. Celestine stood. She looked older than she had when she arrived. Grief and anger can do similar things to the face, and what I saw on hers was something between both of them. She said, "You're making a mistake, keeping us at arm's length. You'll regret not having family around you." I said, "Celestine, Vivienne had no biological children and she had me. She did not seem to lack for family." She said, "We're your blood." I said, "You are, and I don't hold anything against you for what you did today. But I want to be honest with you about something. I have watched Vivienne be treated as an outsider in this family for 17 years. I watched her be described as not really family while she was at every gathering, every funeral, every celebration. I was there for that. I know the language that was used about her in the rooms she wasn't in. And I watched her build something extraordinary anyway, and I watched her choose me because I showed up for her the way she showed up for me. I said that's the model of family I'm going to carry forward, not blood as the default qualification, showing up as the qualification. Celestine looked at me for a long moment. Then she turned and walked out. Theodora followed without speaking to me. Marguerite's attorney gathered her documents and they left. Ramai lingered for a moment at the door, looked back once, and then he was gone too. Roland and I sat in the conference room for a few minutes after everyone had cleared. He said, "She spent 4 months preparing those documents. The letter, the family history statement, the loan documentation, the psychiatric evaluation schedule. She thought about every angle." I said, "She always did." He said, "She told me once that the most important thing she learned in 40 years of law was that the best agreements were the ones where both sides understood from the beginning that they had no leverage. She said that's why she prepared everything so completely. So that if this day came, there would be no leverage available and the choice would be simple." I said, "She was right." He said, "She usually was." I drove home through Houston in the January afternoon. The city was warm in the specific way Houston is warm in January. Not summer warmth, but the persistent absence of cold. The climate that had defined my adult life as distinctly as Providence's rain had defined the stories I had heard from colleagues who grew up in other places. I sat in my car in the driveway of the house I had been living in. The house that was now formally mine, that Vivienne had told me to treat as mine for the 3 years since I became managing partner. That I had been unwilling to fully claim until today. I sat there for a while. I thought about Vivienne on a Tuesday evening in July 17 years ago, driving 2 hours from Houston to Beaumont without calling ahead, to knock on a door and have a 45-minute kitchen conversation that changed the direction of my life. I thought about a summer research program at Rice University and the specific feeling of being in the right environment for the first time. I thought about 114 cases and 97 favorable resolutions and 11 pending and 6 in appeals. I thought about the UT Austin endowment and the first-generation students who would receive scholarships from a fund that bore Vivienne's name, because she had built from nothing and wanted to make the building easier for the people who came after. I thought about the document in her drawer and the 11 months I had held it and the patience required to hold it, and how that patience was itself an expression of everything she had taught me about the relationship between preparation and timing. I got out of the car. I went inside. The house was exactly as it had been that morning, which was exactly as it had been for 3 years. Her books were still on the shelves I had not rearranged. Her photograph was still on the desk in the study. The specific quality of the light through the west-facing windows in the afternoon was still the light she had described to me once as the reason she had chosen this house over every other she had looked at. I sat at the desk in the study. I opened the firm's case management system on my laptop. I reviewed the 11 pending cases and the 6 in appeals. Then I drafted a note to the full staff about the estate proceedings, brief and factual, confirming that the firm's operations would continue without disruption and that the transition Vivienne had spent 3 years planning was now complete. I signed it. Solange Mercier Achafer, Managing Partner, Achafer and Associates. The same name as it had always been. The firm was mine. The work was mine. The light through the west-facing windows in the afternoon was mine. I thought, this is what it means to be left something correctly, not a windfall, not a surprise. A thing that has been built toward you for years by someone who understood what you were capable of and decided to give you the context in which to prove it. I thought, she did not save me. She gave me the context to save myself, the way she said in the letter, and then she watched, and then she left me everything she had built because leaving it to me was the most accurate thing she could do with it. I closed the laptop. The afternoon light came through the windows. I thought, this is enough. This is exactly enough. And I meant it completely, which is the only way it counts. If you have been the person that someone chose, not because of blood or obligation, but because they saw something in you and decided to invest in it, I hope you know that being chosen like that is the most significant thing that can happen to a person. And if you have not been chosen yet, I hope you find your Vivienne. Subscribe and stay, because next week's story is about a woman who waited 30 years for the truth and got it in a room full of people who had believed the lie.